Welcome again. Well, you have almost made it, and this week we'll conclude our semester together. This week we'll take a brief departure from your textbook and go into a deeper exploration of the 14th Amendment. While you may notice that the 14th Amendment does not specifically deal with criminal law or maybe even necessarily procedure, it has a huge impact on criminal law and procedure in general. Adopted in 1868, the 14th Amendment is known as one of the Reconstruction Amendments. It has many provisions. In one case, in its citizenship clause, it offers a broad definition of citizenship, but most importantly in this case, it overruled the held assumption that black citizens could not be citizens of the United States. You may notice that in your Dred Scott versus Sanford ruling. The 14th Amendment's Due Process Clause, as well as the Equal Protection Clause, prohibits state governments from depriving people of life, liberty, or their property without the correct due process. Consider the fact that prior to the 14th Amendment, the preceding amendment, the 13th Amendment, abolished slavery in the United States with the rare exceptions of punishment for crimes that someone might have committed. It wasn't really until the passage of the 14th Amendment that the 13th Amendment had any real teeth. Essentially, any state could hide behind its states' rights provisions and deny its citizens the rights and provisions as listed in Amendments 1 through 8 of the United States Constitution. Prior to the 14th Amendment, discrimination based on race, discrimination based in schools, segregation, and so forth were all legal because they did not apply to states' rights. The 14th Amendment specifically was put in place to remedy that. As you read some of your texts, and specifically the book that is assigned to you, you will notice that the 14th Amendment was not an omnibus adoption type of process. In other words, the 14th Amendment was not written into law and then immediately all other states had to follow the Bill of Rights. Over the next several years, the 14th Amendment became incorporated under what is known as the Selective Incorporation Doctrine. This essentially meant that each particular part of the Bill of Rights would be decided by courts and adopted as needed as the process moved along. This meant that for many years you could still discriminate against individuals, you could still segregate based on race, you could still discriminate against women, you could still discriminate against other non-protected classes. It wasn't until the really 1890s and onward that the incorporation of the 14th Amendment took a real strong form. Today you will notice that we have almost completely incorporated the 14th Amendment into all the other provisions of the Constitution. However, as you read, you will notice that there are many times when the courts seem to go back and forth on the issue. For example, rather early on, they decided that you could not bar black citizens from serving on juries. Yet later, for example, in case of Plessy versus Ferguson, it was decided that separate but equal held true, meaning you could discriminate as long as you did not provide disproportionate amounts of resources to one group or another. The Supreme Court reversed itself on that position with the decision of Brown versus Board of Education, where they held that essentially separate means inherently unequal. This has been a problem that has not been solved easily. In fact, many states fought very hard to have provisions of the 14th Amendment not apply to them. Over the years, however, we have almost total incorporation. In the half century following Brown versus Board of Education, the Supreme Court, as well as other state courts, have adopted protection for other protected groups, such as women, as well as illegitimate children. It is likely that as society expands and as law of procedures change and grows, that different groups will also receive protection under the 14th Amendment.